Welcome back to Winning Isn't Easy. We've been talking about the evidence that you need to establish your disability claim and your benefits. It's crucial that you have the necessary medical proof that's consistent with the policy terms and definitions. I'm going to give you an example of how this blew up and why a financial analyst's long-term disability claim denial was upheld for the lack of medical proof of ongoing disability. You have the burden of proof throughout the life of your claim that you meet the policy or plan definition of disability. Now, this proof is primarily medical proof, and it's in the form generally of objective medical evidence of a diagnosis, objective evidence of restrictions and limitations, and objective evidence that the restrictions and limitations prevent you from performing the material and substantial duties of your occupation or any occupation, depending on what stage of the case you're at. The disability carrier is going to ask your treating physician to complete an attending physician statement form. And generally, you'll see that the APS form doesn't ask the right questions about your medical condition or the right questions about your restrictions and limitations. But nonetheless, you still have the burden of proof. Now, ideally, you should be represented by an attorney such as myself, and you want to supplement the APS form with other documents. What do I mean by that? I'm a Social Security disability attorney, and I will always supplement the APS form, the carrier's APS form that asks the wrong questions, with an appropriate Social Security residual functional capacity form. I want the doctor to answer the right questions about your restrictions and limitations based on your specific medical condition. But the starting point here is, what are your occupational duties? Because we have to prove that you can't do the material and substantial duties of your occupation, as that's defined by the policy. And we want your doctor to understand what your occupation is as defined by the policy. And we want the doctor to address your medical condition and the right restrictions and limitations, being asked the right questions about those particular problems. And ultimately, we want the doctor to support your claim. Now, that can be problematic because your doctor may retire, leave the practice, or your doctor may simply say, I'm sick and tired of filling out these forms. Or worse yet, the doctor may say, I don't support your claim anymore. So let me give you an example of two cases with the same problem. I call it trouble in paradise. The first is the case of Cloncar versus Hartford Life. And Cloncar had been a financial analyst for Robert Bosch Steering, LLC, and he stopped working because of a stroke. Now, his occupation had a high degree of cognitive functioning that clearly could be impaired by a stroke. He was paid short and long-term disability benefits, but over time, his physicians no longer supported his claim. In fact, some refused to fill out APS forms, and only one of them remained of the opinion he could not perform the material and substantial duties of his occupation. Now, the other case is the case of Mr. Bustetter. Bustetter was a tank truck driver, and he developed transverse myelitis, which is an inflammatory disorder of the spinal cord. He had numbness and tingling of his legs. As a result, he was paid his own occupation benefits. But when his definition of disability changed to an inability to perform any occupation, it turned out that none of his physicians or therapists felt that he was unable to perform the material and substantial duties of any occupation. And as a result, his claim was denied, and he filed a lawsuit. Both of these cases ended up in court with federal judges who were looking at the medical records and looking for support of the restrictions and limitations, because ultimately the judge has to apply what's called an abuse of discretion standard unless there's a de novo standard of review. The abuse of standard review basically says that the judge has to accept the denial or termination of benefits unless that denial or termination was unreasonable. If your physicians don't support your claim, or if your physicians indicate that you're capable of working in some capacity, clearly you don't have the medical proof to establish that you're unable to perform the material and substantial duties of either your own or any occupation. And as a result, this lack of medical support in both cases was fatal It takes teamwork to win an ERISA disability claim, and you can lose your case when your physicians let you down. But as I've explained in earlier episodes, there are ways to get physicians to cooperate, and there are ways to find other physicians who can support your claim. So just because your doctor doesn't support your claim anymore doesn't mean your case is lost, but you really do need the assistance of an experienced disability attorney on the team to help develop the necessary medical proof to help you continue to get the disability benefits you deserve. We don't want trouble in paradise, right? Okay, let's take a break.